When you add your child as a joint tenant to your property, then it's a gift, and your child's basis in that property is the parent's cost basis.
Why would someone add their child to the title of their home in the first place?
Okay. We often have clients that come in and they have engaged in their own estate planning, where they know that if they add a joint tenant to their property, then that means if they pass away first, the surviving joint tenant is going to automatically assume ownership of the home. And that means that they don't have to go to probate in order to have their assets oftentimes passed to their children.
Yes, and so there are several different ways to hold title to real estate. Joint tenancy with right of survivorship is one of those ways. The benefit of that is it simply passes to the surviving person, the surviving joint tenant, when one or more joint tenants pass away. So it is a probate avoidance technique. What are some of the concerns then with simply having title held as joint tenants?
Okay, well, there are several things. First, if a parent and a child holds an asset or property as joint tenants, there is a chance that both the parent and the child are going to pass away, thereby still needing probate. That's one issue.
And just to add to that, no matter what, even if the parent passes and then the child inherits it in the way that we think about it, that child still needs a trust at some point.
Yes. But other issues that arise when you just add a child to your home as a joint tenant, when you do that, you're making a gift to the child. Another issue is the income tax. When you add your child as a joint tenant to your property, then your child's basis in that property is the parent's cost basis,
which we refer to as carryover basis. Anytime you make a gift of an asset to anyone, the beneficiary, the donee, receives the cost basis of the donor.
Right. So if I purchased a property for $500,000 and then I added my child later on as a joint tenant, then I pass away and his basis in that property is my basis. So it's 500, even though that property is worth, let's say, $1 million at the time that I pass. So by adding my child as a joint tenant, what I lost was an opportunity for my child to save on income taxes. And if I were to instead have put that property in a trust that says, when I pass away, this property goes to this child, then upon my death, my child inherits this property, and instead of a carryover basis, that child receives a step up in basis to the full market value at the time of my death. And if he subsequently sells the property, he typically will recognize much less in income taxes.
Are there other concerns with adding your child on as a joint tenant?
Certainly liability. If I add my child as a joint tenant to my property and my child gets sued, all of a sudden my house, which I bought, is now subject to that lawsuit because it is an asset that my child owns.
If joint tenancy isn't the best way to hold title on your home, what should someone do if they want to make sure that their home passes down to their child, but also avoids probate?
We should definitely create a trust for that property to be transferred into. And if the parent has a trust, then what the trust will say is, upon my death, I want my house to go to my child. And when that property is in the trust, it avoids probate upon the owner's death. And in the trust, if the child receives the property upon the parent's death, then that child will get a full step up in basis and save a lot in income tax or capital gains.
So if you have any questions about how to properly transfer title of your home to your child, feel free to reach out to us at Modern Wealth Law. Until then, plan well, live well.